Our next speaker is Sharon Bowles, European Member of Parliament from South East England and I guess living in Brussels.
Perhaps I should explain. I've just been a member of the European Parliament for about 18 months. I came into the Parliament in May last year, which was just towards the final stages of something called the CII Directive, otherwise known as the Software Patents Directive. It's possibly of significance to say that my career before I became a member of the European Parliament was as a European patent attorney, and so, as some people know, I've actually played a very big part almost from day one in all matters to do with intellectual property within the Parliament, and I will sort of move on to that later on. But I thought that first of all I would reply to some of the issues that were raised. I think in particular those that were raised in the first session, and I think it was quite helpful that you were able to raise those with the Commissioner present. First of all, the importance of software. Well, I don't think anybody should underestimate it, and indeed during the debate on the CII directive, I did point out that it applied to everything that you could plug in and switch on, and probably a few more things besides, that it is in everything that we use in our homes, that it is in everything that is manufactured that we use. And I don't think that collectively there was a comprehension of the extent of that and the extent of the interaction between things technical and software by many parliamentarians. I think that the Truffle 100 is a great idea for bringing to the fore European software and highlighting the need for it to grow, as you say, on the global stage, and to highlight the importance that public procurement can play in that part. Interestingly, I was actually at a breakfast on Tuesday of this week, which was for SMEs on the matter of, if you like, pre-competitive procurement. And rather interestingly, there were speakers there from, well, initially from DG InfoSoc, and they explained their interpretation of how this could be done, and I believe that they are bringing out a manual. And I think that they were looking at it in a way that maybe I should express is as giving preference wherever possible to European companies. Then somebody else pointed out that DG Trade, in the person of Commissioner Mandelson, has pointed out that we have to be very careful that we do involve a competitive structure within this, that we cannot go out in our trade negotiations to other countries and say, do as we say, not as we do, and that therefore we had to maintain a competitive edge to everything that we were doing. And therefore, then we put on the spot somebody from the third directorate, DG Enterprise, and saying, well, okay, how are you going to deal with this? And we were told that actually DG Enterprise are also bringing out a manual on the subject. So this is about how you can, if you like, sort of how member states will be able to give what is essentially a kind of state aid without transgressing competition rules. So it is up on the agenda there in the Commission, but my lesson to you on this is that there seem to be at least 3 directorates and 3 commissioners that you have to go and talk to about it, and it looks like there are at least 2 manuals that you are going to have to read. And don't wait for them to come to you. I suggest that you do go to them. I see people always going and seeing the Commission every time I'm there, and you know, they do have quite an open door. You may not get to see the Commissioner every time, but you will get to see somebody. And I just say I cannot emphasise how important it is to make that communication actually at national level, because that's how you get to the Council, to the Commission, because that's how you get to the Commissioners, and to parliamentarians, because, well, that's how you get to us. I'll deal with the merger of stock exchanges next before I get on to software patents. This is an interest, the thing that has interested myself and several colleagues, because for my sins, I sit on the Economic and Monetary Affairs Committee. And some months ago, I did raise with Commissioner McCreevy in a debate that, because of course one of the issues that is uppermost in many people's minds when you mention stock exchanges and the United States are the Sarbanes-Oxley regulations, which are sort of very onerous requirements on companies now. And in fact, it has been to the benefit of Europe's stock exchanges that the regulations have not been so difficult and onerous to comply with. I mean, the US does now actually acknowledge that its gut reaction to some of the problems has been to over-regulate, and we expect that there will be some readjustment. But at the time that I was making the speech, there were bids that maybe the London Stock Exchange would be taken over, and the sort of movements obviously on other stock markets. And I pointed out that although it had been said that if there was a takeover or merger between a US and a European stock exchange, that did not mean that Sarbanes-Oxley would have to apply to Europe. There had been a speech by one of the sort of commissioners in the United States that, if you like, I think relatively hinted, or perhaps more than hinted, that once you began to have merger of the technology platforms, that at that point Sarbanes-Oxley might well creep in, because of course it has a lot to do with what's on the technology platforms. So if I extrapolate on from that position that I have taken, if you like, on the Economic and Monetary Affairs Committee to the situation of, well, if we're having new software for our stock exchange trading platforms in Europe, and we want to try as best we can to make sure we don't import Sarbanes-Oxley, I would have said to have had homegrown, provided some kind of first line of defence, rather than buying in something from the United States, which altogether would sound a little bit more likely to be connectable to existing United States Sarbanes-Oxley and all that baggage type of platforms. Now, I don't know who's been dealing with this, but this is again comes to the point of well, which commissioner is dealing with it? I mean, the commissioner that might perhaps agree with what I'm saying might be Charlie McCreevy, who deals with financial services and the internal market. And this is the point that I make. If you've got something to say, that these things now spread over and between so many different commissioners, that you actually do have to do the rounds of anybody that might be relevant. So do go and see Vivian Redding, but don't forget Charlie McCreevy, and possibly maybe even pay a visit to Peter Mandelson if you think that it's relevant in terms of trade negotiations. So that's and in fact it's an interesting point that also came up at the breakfast on Tuesday, was that if these things are to some extent fragmented within the Commission, how can we ever stop having a fragmented internal market? That with different directorates doing things, and okay, they do talk to one another, but quite often there are quite different viewpoints. And as a parliamentarian, I've come across this a lot of the time. And we sometimes have it when we are trying to negotiate legislation, especially at the final stage, that you can be in a meeting with the Commission and the Council, and if there's two different parts of the Commission there, then sometimes they daren't open their mouth because they'll just contradict one another. And there are elements of that have come around in several sort of recent areas. Okay, so now let's move on. Software patents. Well, As we have heard, and we well know, there's a very big difference between the attitude in the United States and the attitude in the EU. As a precursor here, perhaps I should say that today is actually the first time that I have heard European industry effectively asking for software business patents. Now, if that's the first time I have heard it, I can say, what chance do you think you've got of getting it? Because the already well-established view in the Parliament is that this is a nasty US import, because the companies that have been most vocal for it have actually been United States companies. Of course, United States everything is always more vocal. It's a difference in their culture. And of course, it doesn't go down terribly well in Europe all of the time. But we actually have to make the European industry voice heard all the time, because that is what the parliamentarians and the Commission will listen to. I think it was very useful that those comments were made this morning in the presence of Commissioner Reding. So, I mean, when we had the Computer Software Directive, the ambition of that was not to allow business software. It was merely to try and formalise the existing position that we had in Europe, which was that you could have a claim that started software for and then described the operations that proceeded in software, but it had to have a technical effect. It's rather ill-defined what this technical effect is, but certainly if it's controlling apparatus, controlling something, moving something physically, there has never been a problem in obtaining a patent. The problem comes when you're getting into things that are completely inside a computer, so that the technical effect is essentially data operations, but there can be some very new types of data operations that a lot of work and time has gone into and deserve to be protected, and patents for those have been granted. I mean, I'm sure that I have written patent claims to data operations. Of course, those that opposed the directive opposed anything to do with anything that went on inside a computer. In fact, they then ended up drafting amendments that went so wide that, as I pointed out, you'd never get a patent for anything that you could plug in or switch on, which meant that for, if you like, the electronic industry and everybody else, there was just so much potentially damaging stuff that might have been passed as an amendment by the Parliament, we don't know, or if it had gone to conciliation, that might have got into the directive, that everything would have gone backwards, and it was just rather safer not to have a directive at all. So, I mean, there are probably at least 6 different factions behind this, but my advice to industry at that stage was that we can't have this directive because it's too risky, that something bad will come out of it. There were those people who thought that their interpretation of something bad, that it would authorise something that they didn't like, didn't want it, and so it just bit the dust at second reading. And certainly Charlie McCreevy has absolutely no intention of going down that route again. It put him off doing anything much on intellectual property altogether. And it was only the cries from industry saying, well, look, we've got lots of cost problems and so on, that caused him to hold his patent consultation earlier this year. And as a result of that, he has decided, and the Parliament and indeed the Council have said, well, get on with seeing what you can do on the European patent litigation and so on. And that would reduce the cost, if we could get it, of enforcing patents. And of course there's the prospect of this thing called the London Agreement, which would reduce translation costs. But I don't think that anybody is actually addressing, in the way that it was brought out this morning, that there is a gap for European businesses that are actually writing what would be deemed as, if you like, pure software or business software, that you can protect it in the United States, but you can't here. And of course, if you're a United States company, what do? Well, the first thing is you go to your national patent office and you patent it there. You take advantage of the priority period and you see where else you can patent it. And you can in Australia and many other countries, but you can't in Europe. But if you are indigenous to Europe, your first instinct is you go to your patent office or your patent attorneys, and when you find out you can't do it here, then you don't think, aha, but yes, I can still apply for a patent, even though I'm European and I can't patent it here, I can still apply in the US and Australia and elsewhere. Now larger developed companies might begin to think that way, but it's an awful lot to ask of an SME when they probably are not yet thinking of going into the United States or elsewhere. But of course, it could well be in their business plan further down the track. I haven't given you any answers here, but I think I've given you an analysis of a little bit of how thinking is. And I think that there is absolutely, unfortunately, no appetite at all for there to be business software patents in Europe. And you would have to campaign for it quite vigorously if you were to change that. And incidentally, this thick piece of paper here is the Gowers Review on Intellectual Property that was published yesterday on behalf of the UK Treasury. And in this, it does not suggest that the UK should go down the route of business software patents, and it suggests that the current situation with software of them having to have a technical effect is where it should stay. I haven't got all the way through it. I'm beginning to think it could have been a bit more ambitious, but at least it hasn't gone backwards. So thank you.
Thank you very much. A couple of questions, and I apologize if they're not easy ones because the topics are not easy ones. First, there's the topic of is patent good or bad for the industry? Is the patent good or bad for the European industry, which may be a slower starter than the US industry, so it may backfire? So I'll start with a question to the room. Just to make it more interactive, I'd like to ask the participant here, in your opinion, in your either qualified or humble, could you raise your hand if you believe it would be good for software to be more protected through patents, so some form of patent? Please raise your hand if you think patent for the European software industry would be good. It seems there's a majority or a 50% split here. So it's not so bad. The voice I hear from the venture capitalists I've interviewed is, we want a patent, and obviously I will ask also the VCs in the room, especially Truffle Ventures, to eventually comment or contradict me. So, in your opinion, what's the time frame and how do you see it? And the room will be welcome to comment on this topic, and then we'll go to another one.
Yeah, there was quite a significant lobby for that. In the context of discussions on the FP7 framework, there were people proposing that if public funding was used for something, then there should not be allowed to be a patent on it. Fortunately, we managed to point out that exactly the opposite rules apply in the United States, that where there is public money put in for public procurement purposes, they are expected to take out patents as part of that process, and indeed if they don't, the right to take out the patents reverts to the US government. For the second half of the CII debate that comes entirely, it seems, from intellectual sources in some institutions, led us down, I think, very many of the wrong tracks. Recently, just this week in Council, when the Finnish presidency tried to get talks on EPLA going, they came to a standoff between Germany and France. So I understand Germany is very keen to get EPLA off the ground, but France wants to impose a sort of overarching European judge on everything, which to my mind, and I think the mind of many, would undo one of the very good proposals in EPLA that are court of first instances in your own country. I do understand that there are maybe there are differences in national courts and the specialities of them, but you have to get underneath and find, right, what are the problems with France. But we have very severe problems with them in terms of EPLA, maybe even the London Agreement. So any contacts that you have there would be very helpful. On the actual issue of whether we might get these software patents at all, and I have to say, for my own part, I haven't been terribly keen on them, partly because it's we're having to run to maintain the status quo at the moment. There is such a mood of anti-intellectual property. It is actually a very vocal minority, but the silent majority is just that, silent. And it has got to the point that on things to do with intellectual property, indeed on things to do with science, one has to lobby to stop the vocal minority's view appearing to be the dominant view, just because one gets more letters or emails. Bear in mind, the Commission and parliamentarians are politicians, and what's the first thing they do? They weigh in their inbox. And so if there are 1,000 similar messages there from people who have been hoodwinked into thinking they're going to be impoverished, then they take notice of it. And you have to do likewise. But somebody mentioned this morning the fact that IP valuation, of course, is now part of the international accounting standards. And I do believe that this is going to begin to raise awareness, because it's, for our quoted companies, it's going to make a difference to their share prices. Now, this is also something that there is just some stirrings of awareness, again, within Charlie McCreevy's department, which is streets ahead of anybody else on this. And they're aware that there are patents that need licensing and so forth. And I have been actually trying to put together the different branches of this, because at the moment there are sort of economists that are talking about this. There are patent attorneys that know about patents and licensing and so on, and then there are the sort of the markets, but the whole lot has not been connected together. But the fact that it's there and in the international accounting standards before long is going to make all these things join up, and the impact on markets and share prices and the competitiveness of not just our software companies but all companies, because they all have IP, is again going to sort of weigh in. And when it does, I think that it will be weighing in on the side of the argument that you are on, that if we want to take advantage of this, we have to modernise and see what we can do. Where there has been good and valuable resource and research put into things, then it does need to be protected. And sometimes for software, copyright, although it has the advantage of lasting a very long time, sometimes it is not the best solution. So I'm sorry, I don't think yet it's on the horizon, but the direction that I see, if you like, as well as perhaps more lobbying from people here, is the impact of IP valuation.
I want to rebound on one of the topic, specifically translation cost for patents and the London Protocol, how it's called. A couple of months ago, the magazine Decidem had a special issue on intellectual property, and basically our staff, our editorial staff, was very much pro London Protocol. And the reason why we were pretty pro to start with was, our editorial staff is pretty open, pretty international, speaks English fluently, and it sounds like a good thing to reduce translation cost. However, to make the story short, after 2 months of interviews with the market participants, being large companies, small companies, patent attorneys, and so on, government officials, our editorial staff was not devised, was very much against the London Protocol, and not because we're French and because it comes from London. The reason is because it's clear that there's the cost of translation for the patent applicant, the company who applies for the patent. And obviously the cost for those people with the London Protocol goes down because you have less translation to be made. However, for patent user, especially the small company, imagine you're a small company and suddenly a German company sues you because you have not beware of their German patent, which is in German. Well, guess what? I'm a small company. I don't read German. Okay, so the reduction of translation costs for the patent applicant is also a higher cost for translation for all the users. So then the question into the staff, the editorial staff at the magazine Décideur, was, okay, should the burden be either on the European Commission and or public official in general, being the patent agencies in France or in Europe? Should the cost be for the patent applicant who gets the benefit of the monopoly, or should the patent cost the translation cost, be beared by the user or the potential infringer, which doesn't even know there's a German patent or a Japanese patent translated into German, because that happens also. And basically, that's why I think either France and that's just to be an example, our editorial staff was pretty much against the London Protocol, though it sounded like a great idea. Now, this is just an input, and I'd be happy to have either the room or you comment on these ideas.
Well, first of all, I think the London Protocol would help enormously. It's always very embarrassing talking about this when you're British, and by and large we tend not to go around trying to promote English because we think that we have an unfair advantage, and we're aware of the sensitivities of other languages, and often on things we don't even vote on it because we don't think that it's fair that we should, if you like, be seen to be trying to bully everybody to use our language. And the reality of it with a European patent is that most of them are in English. That if you're searching amongst patent literature, then you're going to be looking at patent abstracts, all of which are available from Derwent and other sources in English. So if you actually want to do some kind of comprehensive patent search, there's not much alternative other than to be working in English. And therefore, there are many people that do perceive it as vital that there is always an English translation available so that you can search easily instead of having to search in multiple languages. Having said that, I think that there is a lot of sympathy for other proposals, such as that the patent should be, if you're looking at it from the patent applicant side, that it's in your own language plus English, so there's always your own language there. And then looking at it from the potential infringer's point of view, as I said, if you're trying to do a search in advance to know whether you're going to be clear of infringement and looking at literature, you're essentially you have to work in English. There is no other practical way to do it. But there are proposals that damages for infringement in a state cannot apply until there is actually an official translation. So that if your patent were only in English, let us say, and it's Europe-wide, or it applies in France, you would not be able to start a French infringement action and take action against a company until you had provided them with a French language copy. So it's essentially then they would be able to look at the copy, say, oh, whoops, sorry, well, I'll have to stop or take a license, and you would negotiate, because there would not be damages payable backwardly from the time until the translation arrived. And I mean, it's easy to see how this could be formalised so that you would have as the front end of a potential patent infringement action, instead of the the rather difficult problems that you actually have as an attorney now in what you can say, writing to somebody saying, by the way, we think you infringe. If you come out too strongly, you can or analyse it too far, then you can find yourself on a counterclaim for threats. So to be able to actually go to somebody, say, look, we think you're infringing our client's patent. Here is a translation in your language, sort of, as the opener, I think could actually be quite useful in more than just the translation context. And I think those are the kinds of proposals that I'm happy to see develop. And I think that Charlie McCreevy, again, is thinking along those lines of putting conditions like that into the EPLA. Because EPLA isn't perfect yet, but I mean, because now that the Commission is getting involved, that I think that there will be a momentum perhaps to make tweaks to it, and maybe also to the London Protocol. But I think this is more a matter for EPLA that could improve matters.
So the dialogue is open, the debate is open on the pros and cons, and it's tough issues, as we mentioned, to start with. I would like you to join us to thank you and to thank our panelists here. Thank you very much.